and thank you for being with us tonight. Welcome to the Daniel Webster Debate Series, hosted by the Georgetown Law Federal Society. This series is dedicated to Daniel Webster, one of our nation's most revered orators and public servants. Webster relied on the strength of his ideas to advance the American people's liberty and prosperity. He is readily remembered as a great expounder and defender of the Constitution. Our resolution tonight concerning universal remedies is should courts issue nationwide injunctions. We are honored to host Judge John Bush, Ohio Solicitor General Elliot Geiser, and FIU Dean Howard Wasserman in joining us tonight to discuss this critical question. See what I did there? That pun was a little bit of injunctive relief. We're deeply grateful to the Federal Society and to Georgetown Law for making this debate series a reality. I now want to recognize Drew Benson to introduce these three stellar panelists. Please give them a warm welcome.
The Honorable John K. Bush serves as a judge on the United States Court of Appeals for the Sixth Circuit. Prior to joining the court, Judge Bush was a partner in the Louisville office of Bingham Greenbaum Dahl LLP, where he also was co-chair of the firm's litigation department. He began his legal practice in the Washington, D.C. office of Gibson, Dunn and Crutcher LLP. Judge Bush served as a law clerk for Judge J. Smith Henley of the United States Court of Appeals for the Eighth Circuit, and he received his BA from Vanderbilt University in 1986, summa cum laude, and his JD from Harvard Law School in 1989, cum laude, where he was an Ames Moot Court finalist and an executive editor on the Harvard Journal of Law and Public Policy. Elliot Geiser serves as the Solicitor General of the state of Ohio. The Office of the Solicitor General represents the state of Ohio and its agencies on appeals in the U.S. Supreme Court, the U.S. Court of Appeals for the Sixth Circuit, the Ohio Supreme Court, and other state and federal courts. Before his appointment as Ohio Solicitor General, Mr. Geiser worked at Jones Day in their Columbus office. He served as a law clerk to Justice Samuel Alito, Jr. of the Supreme Court of the United States. He also served as a law clerk to Judge Naomi Rao of the D.C. Circuit Court of Appeals and to Judge Edith Jones of the Fifth Circuit Court of Appeals. Mr. Geiser received his BA from Hillsdale College and his JD from the University of Chicago Law School. And Professor Howard M. Wasserman is Professor of Law and Associate Dean for Research and Faculty Development at Florida International University College of Law. Professor Wasserman previously served as a visiting professor at St. Louis University School of Law and Florida State University College of Law. Professor Wasserman's scholarship focuses on the freedom of speech and on the role of procedure and jurisdiction in public law and civil rights litigation. Following law school, he clerked for Chief Judge James T. Giles of the United States District Court for the Eastern District of Pennsylvania and Judge Jane R. Roth of the United States Court of Appeals for the Third Circuit. He received his BS from Northwestern University and his JD from Northwestern University School of Law, magna cum laude. Welcome our speakers once more, and welcome Judge Bush to introduce the topic for this evening.
Thank you so much. It's great to be here. It's a privilege and honor to moderate this latest installment of the Daniel Webster Debate Series. Before we begin our debate tonight, however, I do want to remember someone who passed away earlier today, who is a great friend of the Federalist Society, and it was actually a very important mentor for me early in my career. Perhaps the person who comes closest to being the Daniel Webster of our generation, Ted Olson. He was my role model at Gibson Dunn when I was an associate there. And I always think of Ted when I come to Washington, D.C., believe it or not, and I'll continue to do so. And he and his family are in my thoughts and prayers, as I'm sure they are for all of you today. So when I learned that Daniel Webster is the namesake of this series, I immediately thought, for some bizarre reason, of this Stephen Vincent Benet poem titled "The Devil and Daniel Webster." I don't know if anyone has talked about this yet. Okay, good. So it's about a fictitious trial in which Daniel Webster successfully defends a New Hampshire farmer who has signed a contract to sell his soul to the devil. And that prompted my first question for tonight's debate. Who is Webster and who is the devil? Just in jest. But I will assume until proven otherwise that we're all on the side of the angels tonight. Our topic, as mentioned, is should courts issue nationwide injunction? Now, in the days of Webster, judges generally did not order relief that went beyond the parties to the case. the devil might be granted the equitable remedy of specific performance of a contract against a particular farmer in New Hampshire. But that ruling did not mean that all farmers who may have sold their souls would be bound by the court's order. Conversely, the farmer who prevailed against the devil in a single case did not, by that single victory, conquer all of the devil's doings throughout the country. One might say that the devil can neither benefit nor suffer from non-mutual collateral estoppel. But with nationwide injunctions, things are different, and that's why they are so controversial. For that remedy, the court generally can bind the defendant as to the outcome for everyone in the United States. And just to be clear, when I say the defendant, I'm not talking about the devil. I'm talking about, well, the government. So how does a nationwide injunction work? Generally speaking, if a plaintiff thinks a law or a regulation is unlawful, the plaintiff can sue the government in a district court with jurisdiction that the plaintiff thinks would be receptive to the plaintiff's arguments. If the plaintiff is right, then that district court, of course, gives relief to the plaintiff. That is, it orders the government not to enforce the law or regulation against that particular plaintiff. But the district court might do much more than that. Some argue that the district court can and should enjoin the government's enforcement of a law or vacate a government agency's rule, not only as it affects the plaintiff before the court. Under this view, the law or regulation invalidated by the court should not be applied to anyone in the entire nation. Now, if the district court's right on the merits of the ruling, no problem. There's something to be said for that nationwide injunction. After all, who would favor allowing the government to act unlawfully as to people when it's been declared what it was doing was unlawful in a particular case? On the other hand, if the district court was wrong on the merits, no one would favor allowing that one judge, in his or her erroneous view, to impose those views on the entire nation and hamstring the enforcement of laws and regulations. The availability of a nationwide injunction creates other difficult issues as well. One is what Professor Samuel Bray has called the shop till the statute drops problem. For those of us who don't particularly enjoy holiday shopping, this objection resonates. If the plaintiff loses the first suit against the government, that does not stop the plaintiffs from suing the government again and again until the challengers finally find a district judge who agrees with them that the government acted unlawful. The government, by contrast, does not have the prospect of such an enjoyable shopping experience. Essentially, the government is like the person who has to sit in the chair while the significant other is shopping and hope that the shopping doesn't buy too much. Translated here, the government must win every suit in every district court, and if the plaintiff wins a nationwide injunction in a single court, the shopping experience ends with a very expensive checkout for the government. Another issue is when courts create a Scylla and Charybdis. They put the government between a rock and a hard place when one district court declares a law or regulation unlawful, while another district court upholds it and may even order the government to enforce a policy that the other district court has held as unlawful, as invalid. So if both district courts give their decisions nationwide effect, what is the government to do? It's been argued that the nationwide or universal injunctions are contrary to the traditional equitable power of courts to render relief that is directed only to the parties before the court, not non-parties. Some originalists would point to the case or controversy requirement of Article 3 as a textual basis to argue that nationwide injunctions going beyond the parameters of a case or controversy, as understood by the founders, is unlawful. In response, some have argued for an understanding of Article 3 that allows Congress to create new remedies by statute to supplement the traditional equitable remedies. And some, including one and perhaps both of our panelists tonight, take the position that Congress constitutionally did so through the Administrative Procedures Act. Now, the APA empowers courts to set aside unlawful rules, and there's abundant lower court case law recognizing that a district court may employ that set-aside remedy to vacate a rule entirely such that it may not be enforced against anyone, not just the party challenging it in court. Now, the rules of vacature of rules and nationwide injunctions are fairly recent in origin. Courts did not start issuing universal injunctions until the 1960s for the most part. But really, the national injunction phenomena didn't really take off until the Obama administration, and it picked up steam in Trump 1 and remained unabated in the Biden years. And I imagine it will continue during Trump 2.0 unless there is some sort of reform. I would submit change could come through either the judiciary itself or through a legislative fix, or perhaps both. In this regard, I recall two other, quote, innovations from not too long ago that, like universal injunctions, raised significant issues under Article 3 in the separation of powers. Now, I must confess my age here. The year I was the 3L was when the Mistretta case came down, which maybe some of you may not know of, but it was a case involving the constitutionality of the U.S. sentencing guidelines. At that time, they were mandatory. And around that time also, there was a case called Morrison v. Olson. Olson as in the Ted Olson that I mentioned earlier today. And of course, that dealt with the constitutionality of the independent counsel statute. And in both Morrison and Mistretta, Justice Scalia, you may read his dissents today. I don't know if you still do or not, but they're very powerful dissents based on Article 3 and the separation of powers as to why the independent counsel statute and the mandatory nature of the U.S. sentencing guidelines violated the Constitution. Now, he was a voice crying in the wilderness at that point. But afterwards, and many years later, it seemed that everyone came around to Justice Scalia's position. Both the independent counsel statute and the mandatory sentencing guidelines went away. Now, for the sentencing guidelines, it was a judicial correction. The Supreme Court held that their mandatory nature violated due process. So what Scalia had argued violated separation of powers, eventually he got his result through the holding in Booker that they violated due process. So that was a judicial fix. For the independent counsel statute, the change came through a legislative fix. The statute was not renewed, and that happened because the shoe had been on both feet. Republicans were not happy with what had happened during the investigations of the Reagan administration, and the Democrats were not happy about what happened during the investigations of the Clinton administration. So I wonder whether a similar scenario will now lead to the demise of national injunctions, now that they've been repeatedly used against two Democratic administrations, one Republican administration, and with Trump 2, yet another Republican administration to come. One imagines the new round of lawsuits undoubtedly soon to be filed against the new Trump administration, seeking universal injunctions and nationwide vacature of agency rules, perhaps might lead to some sort of a legislative fix. Tonight, I hope that our debaters, Solicitor General Geiser and Dean Wasserman, will address these types of issues. And I'd also like them to consider the constitutional issues raised by national forms of relief. I don't know if we're going to have much debate on that, but I think we need to address it. I also anticipate that they will consider the analytical differences between universal injunctions issued in equity by a federal court and the nationwide vacature of administrative rules under the Administrative Procedures Act. And finally, I hope the discussion will dig into what, if anything, the judiciary and Congress should do to change the current system. Both of our debaters have written well-regarded pieces on tonight's issue. Most recently, an article published a few months ago by Solicitor General Geiser and his co-authors on the online site of the University of Chicago Law Review. We're going to begin the debate with his article as the point of focus. So on that note, I will ask Solicitor General Geiser to go first in tonight's debate. So General Geiser, the floor is yours.
Thank you very much, Judge Bush. Thank you to the Federalist Society for having me. I'm here to tell you, you should not be misled by false distinctions. And I'm going to try and draw tonight a distinction that perhaps my interlocutor will describe as untenable. Certainly, the very great Samuel Gray, already mentioned tonight, has decided that the distinction that I intend to draw tonight will be untenable. I would submit to you that it is not, that it is actually imperative. And I'll start with first principles. The thesis is that while nationwide injunctions in equity raise serious constitutional issues and are presumptively unlawful, universal or cosmic injunctions that operate in persona against government agents is unlawful, is distinct from agency action reviewed by a court and subject to set aside or vacatur under the Administrative Procedures Act. And I'm going to look at the text, the precedent, the history, and then some first principles about why that distinction is imperative. Let's start with the first principles and then work our way from text to precedent to history. On the question of first principles, begin with what the separation of powers involves. And discard for a minute all this discussion about the fourth branch of government. No such fourth branch actually exists. It exists as a way to describe a phenomenon that perhaps through neglect, our separation of powers has slipped and slid. But formally speaking, there are still only three branches if you look at your Constitution. And if you look at the statutes in the federal code, you'll find that they are only three branches: the legislative, the executive, and the judicial. And each of them have distinct and defined powers. You probably remember this from Schoolhouse Rock. The legislature makes the law, the executive branch enforces the law, the judiciary interprets the law in specific cases and controversies. And this is true and written in miniature in the state that I represent in court. So Ohio has a legislature, a judicial system. They have an executive branch. It's not a unitary executive because the attorney general is independently elected from the governor, and other states can set things up in a certain way. But most of the governing that is happening in the United States at both the state and the federal level no longer happens in the office of the presidency, or even at the US Supreme Court, which only hears about 60 cases per year, or in the legislature, where Congress has fallen in the number of bills that it adopts, and the scope and sweep of its legislative powers seems to have declined year over year. So what are we left with? We're left with executive branch agencies at the state and the federal level doing almost all of the governing. And they do almost all the governing at the federal level pursuant to the Administrative Procedure Act. And so what happens when the government is being reviewed under the Administrative Procedure Act? Well, it's very different when a court is reviewing legislation that is adopted by Congress from when it is reviewing regulation. And I think this is the most important distinction to draw from a first principles standpoint. Legislation comes from a co-equal branch to the judiciary, and it comes in the form of bicameralism and presentment. It reflects the popular will in a meaningful and legitimacy granting way. And so when a court is analyzing the consistency under Marbury versus Madison of a statute with the Constitution, it's effectively engaged in a conflict of laws and a choice of laws question. Does the statute that Congress adopted govern this particular dispute, or does the Constitution instead? If there's a conflict between Constitution and statute, then in the case at hand, the court applies the law that is higher, and there is a principled and textual in the Supremacy Clause right of way given to the Constitution. When a court is reviewing a regulation, the regulation might have legal consequences. In fact, if it's going to be reviewed at all as final agency action under the Bennett versus Speer test, it has to be both the consummation of the agency's decision-making process, and it has to be something from which legal consequences flow. But it is not law in the same way that a statute is law. And so the choice of law question is now different. And the Administrative Procedure Act in its text, so moving from principles to text, makes this clear. And the part of the text that gets all the action is 5 U.S.C. 706. That gives courts an obligation to hold unlawful and set aside agency action that is illegal and unconstitutional, that didn't comply with the substantive procedural process that Congress laid out. And there's a debate about what set aside means. I think if you look at the 1941 Attorney General Jackson report about the Administrative Procedures Act that was then proceeding through Congress, the Walter Logan bill, he says that, quote, a judgment adverse to a regulation results in its being set aside. And so that was the understanding at the time, that set aside meant that the regulation itself is nullified. The article that I published that Judge Bush referenced is called The Truth of Erasure. When you review an agency action and it is unlawful because it didn't follow the procedures or it's otherwise contrary to law, exceeds the statutory authority of the agency, it's gone. It is erased. And that was also the understanding of set aside in other acts of Congress. So in the 1937 Act that channeled certain challenges to statutes, it used the term set aside to mean nullify. And in the 1942 EPCA, the Emergency Price Control Act during World War II, that also presumed that certain orders or rules adopted by agencies would be set aside and rendered null and void. It used that language. Precedent supports this, but look at 706 in light of 705. 705 gets a lot less attention. That gives the court the authority to, quote, postpone the effective date of a final agency action. How would postponing the effective date proceed in an individual party specific way that maybe an injunction against the defendant as to the plaintiff would proceed. Usually rules have a date that is effective. This presumes that the court could look at that rule and just like scratch out that effective date and write a new effective date at some other later time. And if you can do an interim remedy like postponing the effective date, then maybe set aside is best understood as operating on the agency action itself. Which brings you to the precedent that every circuit has affirmed that an agency may set aside and therefore erase agency rules. Supreme Court justices' statements have made that clear. And then Justice Kavanaugh, just this past term in Corner Post, makes the interesting point that if you, in that case, someone was challenging a regulation, even though they were not the regulated party. And the court concluded that they had standing. And the reason that they had standing is because that regulation reduced their economic prospects in the marketplace, and they had testimony to establish that. Well, how could it benefit them if you only set aside the rule as to the specific party in the case? It would only make sense that they would have standing if there is redressability through vacating and eliminating the regulation to begin with. And so this brings us back to what is actually happening when a court is reviewing under the APA agency action. I think the best analogy is to think of what Congress thought of the administrative state when it adopted the Administrative Procedures Act. It thought of administrative agencies as quasi-judicial courts. They were not part of the judicial system, they were part of the executive branch, but they operated like a bankruptcy court or like a magistrate judge. And most of what agencies did was actually not legislative rules where they promulgate something that goes into the Federal Register. Instead, they were orders in specific cases. And so the idea was you were to take the administrative agency and place it under the appellate review model of federal district courts or federal courts of appeals. And so vacatur is a classic appellate judgment line for what you might do for an unlawful or erroneous lower court decision. And in fact, bankruptcy judges regularly have their decisions reviewed by those who are adversely affected. Even if the bankruptcy has many parties, a particular party can review the bankruptcy judgment, and one of the many remedies that is available to the district court is to eliminate and completely destroy the bankruptcy plan that the bankruptcy court did if it is in fact an unlawful action. So we'll probably get to some counter arguments later, but I think the text, precedent, history, and the first principles here make clear that while universal injunctions in equity raise serious problems, none of them apply to the Administrative Procedure Act.
We'll now hear from Dean Watson.
Thank you, John. I wasn't sure if you were going to come and do the film.
Oh, don't sell me short.
Good evening, everyone. Brady, thank you to you and the Federalist Society for inviting me, and thank you all for coming this evening. I want to save direct responses to General Geiser's proposal for a little bit during the broader discussion, and I just want to start off with some general points. So first of all, I want to tweak the title of the debate here. The question is not should courts issue nationwide injunctions. The question is whether the court should issue universal injunctions, because the issue is not the geographic scope of the injunction. The issue is whether the court can issue an injunction that prohibits the government from enforcing the law against the universe of people against whom it might be enforced, the plaintiff as well as everyone else who might be affected by that law. So reframed, should courts issue universal injunctions? The answer is no, regardless of the nature of the legal rule at issue, for several reasons. Number one is to think about what the judicial power under Article 3 entails. And the role of the court in the ordinary course is to resolve specific disputes between specific adverse parties, to enter a judgment in that specific dispute that resolves that dispute, that declares the winner of that dispute, and to grant, if the plaintiff wins, a remedy that accords complete relief to the plaintiff. And that complete relief should be commensurate with the plaintiff's injury. all right, should be no broader than necessary, no more burdensome than necessary to accord complete relief to that plaintiff. And so universality of remedies is inconsistent with that understanding of the judicial power, all right? Because the court's judgment resolves this specific dispute, declares a winner in this specific dispute, and the plaintiff gets complete relief from a non-universal remedy. The plaintiff gets complete relief as long as the law or regulation can't be applied to him, and that relief does not become less than complete if the law can be applied to someone else. Now, there is another piece to what the courts do, and that is to issue an opinion that declares what the law is, that gives an explanation for the judgment. And the opinion does have prospective non-party effects, but it's not through the law of judgments. All right, it's through the law of precedent, through what future courts will do with that decision in future cases. All right, but the judgment in this particular case is limited only to the plaintiff. Second is standing, which Judge Bush mentioned. Two elements of which are a particularized injury to the plaintiff and redressability. That is, the particularized injury can be resolved or remedied by some sort of judicially granted relief. And there is necessarily a commensurability between that particularized injury and the remedy. For there to be redressability, it must be a remedy that resolves the particular injury as it is defined, but that injury again is particularized to the plaintiff. Third, universality is inconsistent with the idea of departmentalism. The idea that the judicial branch does not have the final word on constitutional meaning, on legal meaning, that the other branches of government have the power to disagree with the judiciary, to act on their own views as to constitutional and legal meaning, including by ignoring judicial precedent. All right. They can't ignore a judgment, but they can ignore precedent, the court's declaration of what the law is. And so non-universal relief better comports with universality because it leaves the non-judicial branches more room to operate. So we have a judgment and a remedy that bars enforcement of the law against the plaintiff. And then we give the government, the political branches of government, some room to choose what they want to do next. Perhaps acquiesce with the court's precedent, perhaps choose to pursue future enforcement. But the other branches get to make that decision up until the point that a new court enters a new particularized judgment and remedy binding the government as to a new plaintiff. Now, the problem with the APA is, in theory, it should be no different in terms of those principles. The problem is the history is all over the map. So General Geiser has taken one view of the history. There are other scholars taking
We have a different debate now. I think you hit the
Yeah,
thing
sorry
and we
about
changed it.
But a number of originalist and historically oriented legal scholars have taken the view that that non-particularized or universal remedies were unknown prior to the enactment of the APA in the 1940s, and the APA wasn't designed to do anything innovative. It was simply designed to put in place what the existing law was. And so Sam Bray, who's already been mentioned, Matthew Adler, Ronald Cass, John Harrison, and others have taken the view that there were no universal remedies pre-1946 or 1947, and the APA didn't change that. The problem is a misunderstanding of the concepts described above, the difference between judgments and opinions, departmentalism. And so it led to a misunderstanding of what is going on. It's a misunderstanding that came up in the Corner Post case, because for a lot of our history, administrative cases were channeled into the DC Circuit. And what the DC Circuit would do would grant party-specific, non-universal relief in a case. And then the agency would decide not to pursue any further litigation, knowing that the DC Circuit had just decided that this rule was invalid, that precedent from the DC Circuit was binding, and it was a fool's errand to try to enforce against anybody else because they knew they were going to lose. And so they acquiesced to that binding precedent in the circuit. So what you ended up with was something that looked universal because it was one case, one decision from the DC Circuit, and that ended all attempted enforcement of that rule. The problem is it's not universal because what was doing all the work was not the judgment in the first case, but rather the DC Circuit's precedent that guided the agency. What's shaken the system up is the fact that everything isn't being channeled into the DC Circuit anymore. We now have cases being brought in districts and circuits all over the country where one decision can't bind anybody else. One district court can't bind anybody. One circuit can't bind any other circuit. And so what we've seen is courts impermissibly, in my view, filling the gap by issuing that remedy or that judgment and remedy in the one case and calling it universal. All right. That is inconsistent with the general principles under which the courts operate. Thank you.
Okay, I think what we'll do now is give each of you 2 minutes. We're going to keep it short to respond to the others' remarks. So, General Geiser, why don't you go next?
Is here fine, or should I stand up? Your pick. All right. Well, I'll just keep it seated for a moment. I think what Dean Wasserman says is completely correct when it comes to injunctions, but I think it makes a big mistake in conflating injunctions by district courts when they operate in personam against other individuals. And I think it conflates that with the appellate review model that the APA established. And it doesn't really address the statutes that I mentioned, the 1937, the 1942 acts that also used set aside, and orders under those particular acts operated nationwide and operated on the agency's action itself. So when you are under the APA, what you are really looking at is the agency action. And part of the primary basis to challenge an agency's legislative rule is that they failed to take the right procedural grounds. If you're looking at the procedural grounds behind the rule and you say, hey, you didn't actually adequately explain, this is therefore arbitrary and capricious, you're attacking the process, not the outcome. And so it would make sense for Congress to say that a rule that goes through a defunct process is supposed to be vacated, much like a contrary judgment is supposed to be vacated. And if there's an intuition that this is weird, the thing that's really weird is that Congress has given an executive branch agency the ability to legislate nationwide all at once, binding instantly every possible party who might come into contact with that regulation. And as the Supreme Court in 1967 in Abbott Labs talked about, why you can have pre-enforcement review of regulations is because as a practical matter, regulations require a plaintiff to adjust his conduct immediately. When an agency is promulgating a rule, it is exercising executive power. It is not exercising legislative power. And so for a court to say that this nationwide or universal exercise of executive power can also be universally vacated is no different than saying that the judgment of a district court can be universally vacated by the judgment of an appellate court, or in the fact of several other statutes like the Clean Air Act, reversal is the contemplated remedy rather than set aside. Dean Wasserman.
So a couple of things. So I found the proposal really interesting. And I don't think you put it in these terms in the article, but what essentially the idea you're putting forward is that the regulation is that this is an in rem action. And so the bankruptcy analogy is actually a good one because it's not it is a race. The regulation is a thing that the court is being asked to adjudicate. And in rem actions have always been kind of unique because the court does sorry for the Penoyer flashbacks there. An in rem action has been, in a sense, universal because it adjudicates the rights of the world in that particular race, although the world is a party to the litigation. I don't think the current version of the APA allows that. I don't think it's consistent with the current version of the APA or what Congress, when it enacted the APA, had in mind. That said, it would be a really interesting model that Congress might adopt if we want to get the legislative reform that Judge Bush talked about. And if we're going to do that, then I want to suggest two things that Congress ought to take into account, because the other way of thinking about this is is that the agencies and the judiciary are working jointly to create regulations. The agency drafts it, the court sort of reviews it, and there's a back and forth between them, and they are working together. And if that's the case, then I think we're asking the court to do something unique, and so we should put in place two unique procedures under which the court should operate. One is that everything should be venue channeled to the District of Columbia, should all happen in the seat of government. And the other is that it should operate under the 3-judge district court procedure of 2284, where the case is initially heard or the review is initially done by a 3-judge district court that includes at least one court of appeals judge with immediate and mandatory review to SCOTUS.
Okay. I'd like to make sure I understand each side's position at this point. So, General Geiser, my understanding of your position is that you don't believe it's appropriate to have nationwide injunctions in the normal case outside the APA, correct?
Correct.
But that under the APA, it authorizes a nationwide vacatur of rules.
Yes.
Okay. And then Dean Wasserman, your position is it should be party specific, both in the general equitable case and also under the APA.
Yep.
But then you go further and say we could perhaps Congress could modify the APA to make these additional reforms that you're indicating. Okay. So my question to both of you straight off is there any role of Article 3 of the Constitution in all this? Are you all both of you accepting that this is all constitutional to have a nationwide vacatur? I think you are. I don't know if you are or not. Are we all on board? This is all constitutional if Congress wants to do it.
I'm going to accept the idea that there is something different about the agency model, that if you understand the court doing something non-judicial in working with the agency, and I'm less formalist about whether courts can do things other than resolve cases or controversies, see the federal rules of civil procedure, I'm willing to accept that. In a pure adjudicative posture, no, I don't think courts can do it.
Okay, and do you agree that Article 3 in the normal case prevents courts from issuing nationwide injunctions?
Yeah, I think nationwide injunctions do implicate Article 3 powers and the separation of powers. We say in the article, my co-authors and I, that the Article 3 incorporated sort of an understanding of the traditional equitable powers of a court of chancery at England, and to go beyond what those traditional powers would be to sort of trammel Congress's role going forward, and would be sort of like judicial legislation.
Okay. So the point of contention tonight is over whether the APA authorizes universal vacatur. Is that fair to say?
Yes.
Yeah.
Okay. So what your argument is that the provisions that you've cited of the APA give that authority, and Dean Wasserman, you're saying maybe it doesn't, or are you still willing to consider that point as a?
I will confess to not having not having written about the APA or dived into the history, but from reading the historiographies that's been done, it's up in the air. The scholars who have written about it are all over the place. I find the Bray, Ron Cass, John Harrison position more convincing.
Okay, got it. Anything more you guys want to say about that point of contention?
Yeah, I do want to, I want to make one point, because everyone sort of agrees on one piece of the history, they just disagree on what its implication is. So in the 1930s, FDR had this New Deal. He was talking about scientific experimentation in government, and that meant a proliferation of commissions. Has anyone seen the movie Oppenheimer? So you know how they have this like little room in an administrative bureau, and they're like doing some court proceedings, and Oppenheimer's lawyer's like, that's not fair. And they're like, this isn't a court, you're in an administrative hearing. That was happening throughout the government. And Roscoe Pound and others at the ABA were very concerned about this. And then when Republicans retook control of Congress in 1946, they adopted the Administrative Procedure Act to respond to the proliferation of administrative agencies, which almost all of them operated like courts. And most of what they did was promulgate orders. Now, some of those orders bound more than just the parties to that adjudication, but the vast majority of them don't. So Sam Bray takes the position and says, so it would have been unheard of when an agency adopts a legislative rule, like the regulation that you read in the Federal Register, to just vacate that nationwide just because they had the power to vacate these party-specific orders that were coming out of adjudication. And so my position on that is, no, just because the drafters of the APA expected most administrative regulation to go through this adjudicatory kind of process, didn't mean that they thought that if the agency proceeded to make a legislative nationwide rule, that suddenly the power of the courts could no longer set aside that rule the same way that they might be able to set aside that order. And so if you're going back to the Oppenheimer scenario, what if the order that those judges had was not just about the security clearance of Mr. Oppenheimer, but about the rules for security clearances for all people for all time? Well, and then you sought judicial review of that particular order, you would expect that the court would be reviewing the order itself, not its application to Mr. Oppenheimer or anyone else. Instead, they would be looking at whether or not it consistently followed the Administrative Procedures Act's rules for proceedings, and whether or not it exceeded any of the authority that had been delegated to the agency by Congress. And so that's the thrust of our argument.
Okay. Anything else you want to add?
Nope.
So what do you think about, and I'm sorry to keep coming back to you, but I think we need to respond to Dean Wasserman's points about reform of the APA. Let's assume you're wrong. Okay, that he's right. That these are specific to the parties, that you have to keep your decisions even under the APA that way. What do you think about his ideas about channeling everything through the DC circuit, 3-judge panels? Anything else that you want to throw out?
No, those were the two.
Okay.
Well, so my understanding of the proposal is the 3-judge panel would have the ability to vacate the agency action, no matter how broad that agency action was, whether it was an order specific to 2 parties or an EPA, for example, the greenhouse gas rule, which Ohio is currently challenging in the DC circuit. I think that if the court could vacate that nationwide, channeling it to the DC circuit or to a 3-judge panel could make sense to avoid the run-the-table shopping problem of the fact that the government has to survive 94 different district courts in order for any of its legislative rules to go forward. But I would disagree strongly with the idea that if that 3-judge court could only set aside the regulation as to the dispute between the parties and the government in that particular instance, I think that would fly in the face of the precedents like Abbott Lab and Lujan and the circuit precedent of all the other courts. And it would also really change the shape of government, because as the other thing that happened when nationwide injunctions started happening under the Obama administration is that we had unprecedented regulations during the Obama administration, and states for the very first time started taking an aggressive stance as saying no. So party-specific relief with a 3-judge district court channel sounds to me like we don't really actually want judicial review of the administrative state's universal regulations.
I don't really want to enter into the debate, but perhaps I will at this point. I will defend all the other courts in the country and their ability to vacate rules of the federal government. Why isn't it a good thing that we have diversity of ability of courts throughout the country to take a different mindset from what judges in DC might have? There is a phenomenon called groupthink, which if you have everything being channeled through the same decision makers again and again and again, yes, it does foster continuity of decision making, but on the other hand, it might lead to just going down the wrong road jurisprudentially. There's no opportunity to challenge it. So when you have the opportunity to have rules challenged throughout the country, doesn't that promote the adversarial process in a way? The courts are acting sort of like litigants. They're able to give different perspectives from different places, and then you're able to ultimately the Supreme Court makes the decision as to who's correct. So I throw that out there. What do you think?
Well, so the nice thing about the three-judge district court process is you're going to get the Supreme Court involved mandatorily and immediately.
Yeah, but what about the notion about percolation being important for the court?
We've already punted that by allowing for universal relief, because the first district court to resolve the issue is getting the final word. And so one of the objections to universal injunctions is that you lose that percolation.
So we didn't have that in the abortion pill case, did we? Didn't we have one judge purporting to issue a nationwide injunction and another judge saying just the opposite? So you actually had competing injunctions, I think, in that case, didn't you?
Which is its own, as you discussed, is its own problem.
Yeah, but I guess my question is, how did the agency respond in that instance? Was it the one court, I guess the Texas court, that kind of ruled the day, or did they actually follow how the other court? I don't know who their other court was.
I don't think it was. I thought it was a court in the Ninth Circuit.
Yeah, it would seem to me an agency would have a defense. If you had a court in one circuit issuing an injunction or a ruling in their favor, even though you have a nationwide injunction, why wouldn't the agency have a defense if it's brought up to say we have a valid order from our circuit or this other circuit where we're acting saying it's lawful for what us to do? We can use that as a defense against your order that purports to be a nationwide injunction. I throw that out for you all to think about.
I'll make a policy-based, this is not a legal, historical, it's a policy-based argument, that if you are going to have a government that will change and adjust people's rights with a stroke of a pen, that perhaps needing to run the gauntlet of judicial review is a pro-liberty and pro-freedom approach. And I think that in general, that's a feature. If the current law continues to be what it is, my assumption is that agencies will learn the lesson that maybe they shouldn't do legislative rules with universal effect. They don't have to. The APA allows them to proceed by adjudication. In fact, the SEC, knowing that they would likely face tough sledding in litigation, has started to proceed by individual enforcement actions in federal district courts, just enforcing the act of Congress as they read it. What a novel idea that you don't need a legislative rule and you can just enforce the law that Congress, through the people's representatives, bicameralism, presentment signed by the president, that could be the law. I think that if you allow universal vacatur, agencies will quickly learn that maybe they don't want to promulgate notice and comment rules for every kind of thing. And if individual adjudications under the federal statute without any regulatory guidance if it triggers the objection, well, we don't have enough notice, then maybe that's kind of like a way, without asking the court to do something untenable and draw a bright line rule between non-delegation that is, a non-delegation rule that is a bright line. That's really difficult to conceive of. Maybe it's sort of a non-delegation principle in the negative space, that if Congress hasn't legislated sufficiently, that you can know what the rule requires without a legislative rule. But a legislative rule would immediately be vacated nationwide by the first district court that looked at it. That maybe the statute doesn't give the agency the power to enforce that it thinks that it has, and it needs to actually leave that power to the states, or instead leave people free to order their own affairs, or allow Congress to amend the statute and legislate with sufficient clarity that people do in fact have notice of what their obligations are under the law.
So I'll answer your question, I'll answer
Okay.
Judge Bush's question first and then.
I'm not
I'll
taking a
respond.
position on
No,
this.
no, I understand that.
For the record.
I understood. It seems to me it would really be up to the discretion of the judge. And so you could try to make that as a defense that we are under this competing injunction. We are under this competing injunction. And maybe that avoids a contempt citation, but that really is going to be in the discretion of the judge. And we see enough activity under section 2283 where two district courts, just in ordinary litigation, where a district court, where a federal court and a state court issue competing orders and the plaintiff is put in a bind, or the parties are put in a bind. I think the same thing would happen as between the one injunction that says you cannot enforce this against anybody and the other injunction that says you can enforce it against anybody. You're not required to, so there's not a direct conflict. But I don't think the competing injunction from, I think it was a district in Idaho, is going to save the government from Judge Kaczmarek's contempt order. I'll defend the administrative side. I'm not an administrative law judge or administrative law scholar, but I'll defend the administrative state. For better or for worse, legislation is a lot more complicated. The problems that Congress has to legislate are a lot more complicated. And so the executive, there's always a certain amount of legal interpretation, legal analysis, law to fact application that the executive does in order to make enforcement decisions. I don't see anything problematic or different about the agencies writing those down and making them look like prospective laws of general applicability rather than individual ad hoc decisions.
Okay, how much time do we have?
5 minutes.
5 minutes. We have time for maybe one or two questions if anyone has any in the audience. Otherwise, I'm happy to keep grilling. Yes.
I can just take kind of one here is that it seems like if you go by the more precedent-based approach, where the government is free to ignore essentially and bring another suit, you might end up with a pretty hefty explosion of litigation, where you essentially have the government, even though they know they're going to lose, you can go with a process as punishment and sue different corporations you don't like in different areas and go after them that way, even though the action itself is unlawful and they'll lose in court down the road. Is that a problem you see at all?
I think there are checks on that. Attorney's fees is the big one. That's politics politics and the electoral check is the other. There's a risk in that, but there's anytime you set up a system of government, there's a risk that somebody's going to act in an abusive way. But I think there are checks in place to at least put a drag on that.
I mean, I think that Congress saw that type of thing happening in the 1930s, and that's why they adopted the Administrative Procedures Act. That's why they empowered courts to act directly on agency actions that either didn't comply with the law or failed in some meaningful way to comply with the procedures that were there to ensure sort of due process-like protections for regulated parties.
Okay, I think do we have time for closing statements, or are we okay? Closing statements, General Geiser. Actually, you should have him go.
He'll get the last word?
No, you get no. You get the last word. General Geiser, you go first. Another question I was going to ask you. Maybe you can address this, but you were in a position of representing a party that could be both a beneficiary and a victim of universal injunctions. I don't know what you have any thoughts on it or not, but it seems kind of an odd situation that you're in.
Well, so the position of my office that we've taken on litigation is that courts do not have the power to issue injunctions that reach beyond the parties to the case, but that courts do have authority to vacate administrative rules and regulations, both in state court when it's the Ohio administrative proceeding that is involved, or it's the federal administrative proceeding. So when we sue the federal government, and I don't know if I'm proud of this or not. I'm currently an active litigant against the federal government in 43 cases. I just decided to tally the.
And are you seeking vacature, nationwide vacature of all those rules?
Yes, we
Okay.
are not seeking an injunction, and I chide some of my fellow states who always sue for injunctions, because I'm like, I don't actually think that the court has the power to do an injunction about this, nor do you need to do that. What we're seeking is either a stay to postpone the effective date in the interim while we litigate, or we're seeking vacatur of the rule because the rule was arbitrary and capricious or it exceeded the statutory authority. And with the rule gone, that really is a full remedy for us. And because the court can operate directly under the APA on the rule, the most recent example of this is Texas has been leading, and Ohio's also a party in the parole in place rule. So the Department of Homeland Security said, if you are here illegally, we can parole you into the United States, and we're going to do this on a categories basis. Judge Barker cited my Truth of Erasure article when he vacated the rule nationwide, but the injunction only ran against the parties. And I think that's an interesting distinction that we're trying to press. But when people sue, to invalidate the work of the Ohio General Assembly, I defend in part by saying any injunction that you issue, and you shouldn't issue any of them, but if you're going to issue one, it should be limited to enforcement actions against the plaintiffs in this particular suit.
So Dean Wasserman, is he speaking out of both sides of his mouth here?
No, I actually, I don't think so, because the states are in this unique position. Your eyes are open to it, which is and you recognize the different situation that you're in, because there was a debate over this at the Association of Attorneys General annual meeting in 2018. So we were about 2 years into this whole conversation. Sam Bray had just posted had just written his article, and that got pointed out to them. Is like, you realize this could come back to bite you. And so it wasn't a question of talking out of both sides of your mouth, but as much as realizing the position that this potentially places you as both a defendant and a plaintiff in these sorts of cases.
Okay. Well, with that, we'll call it a night. Thank you for being here. Thank you.